So we're often asked, does my LLC really need an operating agreement? I mean, do I really need to pay an attorney to draft up this document, either for myself or between myself and my business partners? And the answer is absolutely, you need a signed written operating agreement. One of the reasons is because the operating agreement will address the very important question of what happens if this business needs to raise some extra capital to stay in operation. Look, every business runs into a point where it might need an influx of cash. We saw a lot of this throughout the pandemic, especially last year, an incredibly challenging time for many small businesses. But what the operating agreement will do is it will address, okay, how are we going to treat that extra money? In some cases, that extra capital comes from one of the business partners, and they can afford to contribute more money, they can afford to take on more risk. But if the business gets to that point, the operating agreement needs to make it clear, is that extra cash a loan to the business? Does the business partner expect that money to be paid back? Or is that business partner effectively purchasing additional ownership interest in the business? So when you're starting to have these conversations, you can easily skew these carefully considered ownership percentages from what everybody thought they were to something completely different now. And that might even change who the majority owner is in the business. And of course, if we're going to take this extra capital and treat it as a loan, then there really should be a separate promissory note that also details what are the terms of that loan, when is it going to be repaid, is it a lump sum, will there be interest charged, all those types of questions need to be addressed. Because otherwise, I can almost guarantee there will be a dispute later on where somebody will go, oh no, absolutely not, there was no loan, we never talked about a loan, we never talked about paying back that money. Or on the flip side, no, I put extra money into the business. I'm supposed to have a higher ownership percentage now. Well, no, that's not what we discussed. And you can see where these disputes and these tensions start to arise. In other situations, that extra capital might come from an outsider to the business. So maybe you've got a friend or a family member that really believes in you and is like, yeah, absolutely, I'll invest to keep this business afloat. Well, now the company needs to document again, is that extra capital a loan? Is it an equity investment? Is the person that's providing this capital going to become a member of the company? Or what are their rights going to be as a member? Are they just a silent partner? Do they now have a voting rights in the business? So all of these questions need to be addressed. And then, of course, there are multiple legal issues that come with that because the business also needs to address both federal and state securities laws. And that, of course, will require the preparation of even more documents, whether it's promissory notes or investment disclosures and investment agreements and those types of things. But the operating agreement itself should have addressed these questions long before the issue comes up so that we know what to plan for and what to expect in the event of any of these worst case scenarios.